In this video, we are going to cover the law of contracts, the first 10 questions for this subject. The first question is from Clat 2013 examination. Here the principle states that an agreement may be oral or written. However, if a law specifically requires that an agreement must be in writing, then the agreement must be in writing. A law specifically requires that the agreements relating to transfer of the copyright in the case of a novel between an author of a novel and the producer of a motion picture must be in writing. So the facts related to the question are that the author of a novel Love at Last Sight had several rounds of discussions with a producer of a motion picture regarding the making of a motion picture based on that novel. During the last discussion, they decided to make a motion picture on Love at Last Sight. The producer made a motion picture on the Love at Last Sight after making a payment of rupees 10 lakh in cash to the author, who happily accepted this amount and full and final payment. Later, on the advice of his lawyer, the author brought a case in a court of law against the producer on the ground that there is no written agreement between the producer and him. So the possible outcomes for this scenario could be like the first one: the author is likely to succeed in the case as the agreement is not in accordance with the law. The second outcome can be the author cannot succeed in the case as he has given his consent to the agreement. Another possibility can be the author is not likely to succeed in the case because he has already accepted the amount of rupees 10 lakh as full and final payment. Another outcome is that can be possible. The author can succeed in the case as the consideration is not adequate. So here you need to see the first part of the principle, which specifically lays down that the agreement can be oral or written, but if a law specifically specifies that the agreement must be in writing, then the agreement has to be in writing. So here in this scenario, the producer of the movie and the author of the novel, they agreed orally, but there was no agreement which was written down. So in such kind of a scenario, the option A can be the possible outcome, that the author is not likely to succeed in the case as the agreement is not in accordance with the law. Moving forward, the next question that we have is from NLSIU, that is in 1990. The facts of the case were that Mohan promised to take Sundar out for a dinner in Taj Coromandel. Even after 2 weeks, Mohan did not fulfill his promise. Sundar wants to sue Mohan to enforce that promise. So, the legal principle which states that an agreement enforceable in a court of law is a contract. In order for an agreement to be enforceable in a contract of law, there must be a meeting of minds between both the parties. Parties to a contract should do something for the other party. The obligation to do something for the other party is mutual. That is called consideration, and absence of consideration renders the contract unenforceable. So the possible outcomes in this scenario could be that if Sundar goes to the court, he can compel Mohan to buy him a dinner at Taj Coromandel. Second outcome can be if Sundar goes to the court, he can recover the value of the dinner from Mohan. Another possible outcome can be if Sundar goes to the court, this promise will not be enforced by a court of law as there is no consideration from Sundar. Rest is none of the above, like none of the above possibilities could be possible. So here, as per the principles given, the legal principles, there has to be a consideration, and the absence of consideration renders the contract unenforceable. In the given facts, here you can see in the given facts, there exists no consideration from Sundar, and hence there exists no contract between them. Also, Sundar cannot recover any damages and cannot sue Mohan in the court of law because neither does a court of law entertain a social contract of this nature, nor does it take care of trifles. So here in the possible outcomes, the option number C, that is this promise will not be enforced by the court of law as there is no consideration from Sundar, will be the most appropriate answer. Moving forward, the next question is from CLAT 2016. The principle states that an agreement may be entered into orally or in writing or by the conduct. So the facts of the given scenario are: A went to the shop of B and picked a toothbrush and gave a check of rupees 20 to B and left the shop. So in this scenario, the possible outcomes can be: A should have carried a currency note of rupees 20 to make the payment. Second outcome can be: A did not enter into an agreement with B. The third outcome could be: there was an agreement between A and B. The fourth option could be: payment of a toothbrush cannot be made through check. So here what you can see is this is a case of implied agreement, that is the agreement entered into by the conduct. So here A took the toothbrush from the shop of B and left the check of rupees 20. His conduct shows that he was willing to buy the toothbrush, so he left the check. Therefore, an agreement has occurred between both of them. So according to the given principle and the given facts, the possible outcome which could be is the third one, that there was an agreement between A and B. Moving forward, the next question that we are going to cover is from Ailet 2014, and the principle states that once a person accepts another's offer and signifies such acceptance to the former, a contract comes into existence between them. Uncertain agreements are void agreements. So the second principle was uncertain agreements are void agreements, and the third principle states that rejected offers can be accepted only if renewed. So the given facts under this legal principle are that Bakshi wanted to purchase a particular piece of land. He sent a letter to his cousin Dutt offering him rupees 4 lakhs for it. Dutt replied that he would not sell it below rupees 5 lakhs. Bakshi communicated his willingness to pay this amount. Dutt did not sell the land to Bakshi. Bakshi sued him for the breach of contract. So in this scenario, the possible outcomes could be: Dutt is liable because once he communicates an offer to Bakshi and Bakshi accepts it, a contract comes into existence. The second possible outcome could be: Dutt is liable as he has misled Bakshi by his actions. The third possible outcome could be: Dutt is not liable because he has rejected the offer by giving a counter offer, which is also not specific. The fourth possible outcome could be: Dutt is not liable as there is no legally enforceable contract. So in order to find out the possible outcome for the given situation, we need to take a look at the principle first. So here you can see the principle clearly states that there has to be an offer and an acceptance for a valid contract. In other words, the person should accept the offer. It further states that if there is an uncertainty, it becomes a void agreement. So in the given facts that we have, Mr. Bakshi makes an offer to which Mr. Dutt replies by making a counter offer, which is not specific. There is no acceptance given, and hence according to the given possible scenarios outcomes, the third scenario outcome that we have, that Dutt is not liable because he has rejected the offer by giving a counter offer, which is also not specific, could be the most appropriate solution to this scenario. Moving forward, the next question that we have is from CLAT 2012, which was repeated in 2015 also. So the legal principle basically states that when one person signifies to another his willingness to do or abstain from doing anything with a view of obtaining the assent of that person to such an act or abstinence, he is said to have made a proposal. So the facts that we have in this scenario are: Ramanujan telegraphed to Shyam Sundar writing, "Will you sell me your Rolls-Royce car?" Telegram, the lowest cash price. Shyam Sundar also replied by the telegram, lowest price for the car is rupees 20 lakh. Then Ramanujam immediately sent his consent through the telegram stating that I agree to buy the car for rupees 20 lakh asked by you. Shyam Sundar refused to sell the car. So under this scenario, the possible outcomes could be: that he cannot refuse to sell the car because the contract has already been made. The second possible outcome could be he can refuse to sell the car because it was only invitation to offer and not the real offer. The third possible outcome could be it was not a valid offer because willingness to enter into a contract was absent. And the fourth option that we have is like none of the above possible outcomes could be there in the given scenario. So here let's take a look on the given principle first, and here it states that for a proposal a person must signify his willingness to the other party to do or abstain from doing something. So in the given facts that we have, Sham has merely replied with the lowest price of the car, which is rupees 20 lakhs. So this does not signify that he was willing to sell the car at this point. And since there is no willingness to enter into the contract, so accordingly the possible outcomes that we have, so the third option which is there, that it was not a valid offer because the willingness to enter into a contract was absent. So this option would be the most appropriate solution to the given facts. Moving forward, the next question that we have is from Clat 2017, and the principle states that when a person who has made a promise to another person to do something does not fulfill his promise, the other person becomes entitled to receive from the person who did not fulfill the promise compensation in the form of money. So the facts to the given problem are: X made a promise to Y to repair his car engine. Y made the payment for the repair. After the repair, Y went for a ride in the same car, and there he met with an accident due to bursting of a tire. So in this scenario, the possible outcomes could be that X will not be entitled to receive compensation. The second possible outcome could be X will be entitled to receive the compensation from Y in the form of money. The third possible outcome could be Y will be entitled to receive compensation from X in the form of money. And the fourth possible outcome could be Y will not be entitled to receive compensation from X. So here let's take a quick look back on the given principle, and the principle states that a person can claim compensation if the person who had made a promise does not fulfill the promise. So in the given facts that we have, the promise was made to repair the car's engine, which was done by Y and nothing more. So hence Y will not be entitled to receive compensation, that the bursting of the tire had nothing to do with the promise which was made. So in this scenario, the option D, which is there, Y will not be entitled to receive the compensation from X, will be the most appropriate answer to the given scenario. Moving forward, the next question that we have is from Clat 2017, and the principle states that an offer made by one party when accepted by another makes it a contract. So the given facts are like a couple of transactions were there. So it was like P offered to sell his house for rupees 20 lakhs to R. R told P that he was interested to buy a house for rupees 15 lakhs only. Then another transaction was that C was looking for a house for not more than rupees 25 lakhs. And P, who was selling his house, he informed C that his house was available for rupees 20 lakhs. Then another transaction was there that K wanted to buy some old furniture. So L told K that he would sell his furniture for rupees 10,000. Another transaction was there which stated that R advertised to sell his old car for a price of rupees 3 lakhs. S found the agreement and offered to buy it for rupees 2,50,000, and R agrees to sell it to S. So in the given transactions, what they are asking is like which of the above is actually a contract. So they have given certain options stating that the situation 1 and 2 are contracts. So here if you take a look on the first two transactions of selling of the house, so they both were contracts. Then the second option they are offering is that the fourth situation is only the contract. So that the selling of the bike, selling of the old car, the fourth one. So this could be like only the contract. Then they are saying that the second and fourth options were contract. So that is like the house for rupees 25 lakhs and the old car. And further, the last option was that situation 3 was only a contract. So this old furniture one, so this was only the contract and the other were not contract. So in order to understand better, let's take a quick look on the transactions. So here what you can see is in the situation 1. So situation 1 is a counter offer to R. So once again here situation 1 is a counter offer by R. In the situation 2, the situation 2 is an invitation to offer. If you take a look on the situation 3, so situation 3 is an offer. If you take a look on the situation 4, situation 4 is the only contract where there is offer and acceptance of the same. So initially situation 4 was an offer made by R for rupees 3 lakhs, but it was countered back by us for rupees 2,50,000. And the moment such counter offer was accepted by R, it became a contract. So in the possible scenarios, the options that they were asking, that which of the above is actually a contract. So this B option, which says that the situation number 4 is only a contract. Moving forward, the next question that we have is from Ailet 2013, and the principle states that when an offer is accepted by a person to whom it is made, it becomes a promise. But this promise will become legally binding only when the acceptance of the offer is unconditional. So the given facts of the scenario were: Ram makes an offer to sell his house to Sham for rupees 50 lakhs. Sham accepts the offer but wants to pay the price of the house in 5 quarterly installments. Ram does not agree to it. Thereafter, Sham agrees to pay the price of the house in the way as originally desired by Ram. But Ram did not reply to it. Can Sham compel Ram to sell his house to him? So the possible scenarios for the given facts were that the first scenario could be Sham can compel Ram to sell his house because Sham ultimately agrees to pay the price as originally desired by Ram. The second possible outcome could be Sham can compel Ram to sell his house because Sham in the first instance substantially complied with the desire of the Ram. The third possible outcome could be Sham can compel Ram to sell his house because Ram's offer does not exclude the payment of price in installments. The fourth possible outcome could be Sham cannot compel Ram to sell his house because Sham imposed a new condition about payment of price of the house while accepting the offer, which is not ultimately accepted by Ram. So in the given scenario, the option number 4 that we have, that Sham cannot compel Ram to sell his house because Sham imposes a new condition about the payment of price of the house while accepting the offer, which is not ultimately accepted by Ram, will be the most appropriate answer. So here you can take a look on the facts and you can see that the moment Ram did not agree to Sham's quarterly payment, the initial acceptance lapsed, and Sham's subsequent agreement to the contract did not result in any valid acceptance. Rather, it amounted to a new condition which gave rise to a fresh offer. Hence, Sham cannot compel Ram to sell his house. Moving forward, the next question that we have is from Clat 2017, and the principle states that acceptance of a proposal must be absolute and unqualified. So here the facts of for the given principle were: A made a proposal to sell his motorcycle to B for rupees 25,000. B agreed to buy it for rupees 24,000. A sold his motorcycle to C for rupees 26,000 the next day. B sues A for damages. So here the possible scenarios could be that B will not get any damages from A. The second possible outcome could be B can proceed against C. The third possible outcome could be B will get damages from A. And the fourth possible outcome could be B will get the difference of rupees 1,000 only. So here if you just take a look on the facts, B did not agree to A's proposal of selling the bike at rupees 25,000. He instead made a counter offer to A, which was declined by A, impliedly by selling his bike to C. So B and A had no agreement, and hence B cannot ask for damages for the same. Moving forward, the next question that we have is from Ailet 2017, and the principle states that the acceptance must be absolute and unqualified, leaving no ground for doubt or uncertainty. If the acceptance is conditional, no valid contract is formed, and the offer can be withdrawn at any moment till the absolute acceptance has taken place within reasonable time of such offer. So here the facts were that Delhi government conducted an auction for the sale of license of wine shop. X offered the highest bid, which was provisionally accepted, and it was stated that it is subject to the confirmation of the chief commissioner, who may reject any bid without assigning any reasons. So since X failed to deposit the required amount, Chief Commissioner rejected the bid. The government held X liable for the difference between the bid offered by him and the highest bid accepted in re-auction, and commenced proceedings for the recovery of the sum. It was contended on behalf of the government of Delhi that X was under a legal obligation to pay the difference, as it was due to his fault that a resale of the excise shop was ordered, and hence X was liable for the deficiency in price and all expenses of such resale which was caused by his default. So the possible scenarios for the given problem were that X is not liable to make the payment as the shop was sold to the highest bidder. The second possible outcome was X is liable to pay because the government of Delhi has to conduct re-auction and also suffered loss in the sale of the shop. The third possible outcome could be X is liable because his bid was accepted but he failed to deposit the required amount on time. The next possible outcome could be no, contract for sale was not complete till the bid was confirmed by the chief commissioner, and till such confirmation the bidder was entitled to withdraw the bid. So in this scenario, the option D that we have, that the contract for sale was not complete till the bid was confirmed by the chief commissioner, and till such confirmation the bidder was entitled to withdraw the bid. This is the most appropriate answer under the given scenario. For this to understand better, you need to take a look on the principle which was given, and the second part of the principle here is the key. It stipulates that if the acceptance is conditional, the offer can be withdrawn at any moment till the absolute acceptance has taken place, and this is what we need to answer. So in the given facts that we have here, if you take a look on the facts, the acceptance of the Delhi government was conditional. The chief commissioner was to decide whether the action bid by X was formally accepted or not. Until the acceptance was absolute, there could have been no legal obligations and rights on behalf of either of the parties. The bid was rejected by chief commissioner on the pretext that X did not pay the required amount. But as there was no contract until the chief actually accepted the contract, hence X was not liable to pay any amount or whatsoever.